Hi, it's Candice Quinn from the ContractHack. Are you interested in mergers and acquisitions or corporate law?
When are they going to take that down?
Pearson doesn't have the same ring.
Pearson Paulson sounds pretty good.
Maybe you just got thrown into an M&A deal with no notice and no background in it. Regardless, you need to understand what M&A actually is and what you're going to be doing. I've been there. I've worked in M&A in-house, in a firm, and it's a lot of work and a lot of different steps. And if you don't understand them, it's going to be really tough to follow along. And nobody really tells you this stuff until you're deep into the trenches of it at 2 a.m. And that's not a real helpful time to learn. So I'm going to break down M&A in the best way that I know how, with some basic information about the different structures of M&A and the main phases of a deal. Okay, so what is M&A, or mergers and acquisitions? In law school, it's all theory, but in the real world, it's when one business buys another business or two businesses merge. That's the obvious, but it does get really complicated. That's how bankers, lawyers, accountants all make their money on the deal, is by making it more complicated. So there's two basic types of deals: either the asset purchase agreement or the stock purchase agreement. So in an asset purchase agreement, the buyer picks and chooses what items they want to buy. So they take all of the good things and they leave the bad things, like debt. It's basically like shopping a la carte. You get to choose exactly what you want.
Now walk away, strong and frugal. Oh my God, Gucci boots.
Like, you want the great assets like the IP and the top contracts, but you don't want the lawsuits, the liabilities. You want to pick and choose. Now, a stock purchase is when the buyer buys all of the stock of the acquired company. And that means they get everything. They get all of the assets and all of the liabilities. There's no picking and choosing. It's all or none. Now, there are strategic reasons for both of those, but that'll have to wait for another video. For now, just know that asset deals are cleaner, but are more complicated to close. And stock deals are a simple structure, but are riskier because you get everything, all of the skeletons. So why do companies do M&A anyway? Honestly, there's lots of reasons, but the main one is they want to grow faster than they can organically. They might want to eliminate a competitor. They might want to acquire technology, talent, or intellectual property. They may even want to enter a new market. And if the business is already owned by a venture capitalist or a private equity firm, then they may be doing the acquisition just to make more money for that investor. And sometimes an executive just has an ego and wants to build an empire. Like, that's the basic truth. But an attorney's job is not to question the strategy. It's just to help the deal close. And more importantly, make sure the deal closes without your client getting screwed. Okay, so what is the life cycle of an M&A? What are the different phases that you can expect to see and be part of? First, you have the preliminary discussions and the NDA. So different strategic business people are going to be talking and discussing, and then they're going to ping you as the attorney and say, hey, we want to keep talking about this potential deal and we need an NDA. They will talk a little bit without an NDA, but before any real substantive information gets going, they are going to want an NDA in place in order to protect the, top 10 customers, the finances. It's a necessary part of every deal. Now, as a lawyer, you'll either review this NDA or you might draft it or start with a template, but you will be part of this. You want to keep it really tight to protect your client. And deal makers move really fast, so don't let this one sit in your inbox like you might let other NDAs sit. This is going to need a tight turnaround. Okay, so if they make it through the initial discussions, then stage 2 is the letter of intent. And this is when the real negotiation happens on a lot of high level points of the deal. Basically, the parties are saying, hey, we're really serious about this deal, and here's how we're thinking it's going to be structured. Here's what we're thinking the price will be. Here's what we're thinking will be included. Now, letters of intent are typically non-binding, meaning neither side can force the deal to go through. It's not that type of letter, but the confidentiality of it is protected. So if either side backs out, they can't go running their mouth to anyone else about what was in that letter of intent. Now, for attorneys out there, never let the business think that the letter of intent or LOI is just a formality. It is really there to protect the business and make sure the things that should stay confidential in this deal. Plus, the terms you set here really set the tone for the rest of the deal. You're going to discuss the high-level issues in the letter of intent, and those things are going to carry through into the deal and really, quite frankly, be pretty hard to change if they're not properly negotiated at the front. Fighting for good terms now will save you a nightmare later. Okay, phase 3, due diligence. And this is the part where attorneys just hate their lives. It's also where attorneys earn their paycheck. So if you're a newer attorney going through due diligence, you're going to be just stuck in document review. I once worked on document review for 2 medical firms that were looking to potentially merge or acquire each other, and I was reviewing contract after contract from insurance companies for weeks. It sucked, but the firm made a lot of money on it. The due diligence is the chance for the buyer to look under the hood of the seller. They're going to find all the skeletons, they're going to find all the good things, and really evaluate if they want to make this purchase or not. It's also the seller's chance to organize their business and their documents, and a lot of times there's a lot of work that goes into it for the seller as well. While the buyer's reviewing the contracts, the seller's actually doing the organization and trying to find things that probably just weren't maintained as they should have been. Now, as the buyer's attorney, you're looking for undisclosed liabilities, bad contracts with change of control provisions that could blow up the whole deal, intellectual property issues, regulatory compliance issues, litigation risks, employment issues. On the seller side, you're scrambling to pull together every document that the buyer side is asking for. You might need to write memos to explain away concerning issues, and you need to make sure that your client doesn't accidentally disclose something that kills the deal. Now, if you're in-house doing a merger and acquisition, you're probably mostly managing outside counsel, but you're also interfacing closely with the business to help pull together what the buyer is requesting if you're on the seller side, or if you're the buyer, you're also doing a high-level review of what outside counsel has reviewed and pointed out as issues for you. Due diligence is extremely tedious and takes a lot of hours. This is the longest portion of the deal. It's spreadsheets, it's reading for hours at a time, it might be the same type of document 47 times over again, but it's where attorneys prove our value. If you miss a critical issue and the deal closes, that's not going to be good for your client. If you catch a red flag early, you can save your client millions of dollars, and that's worth every penny you charge. Now, phase number 4 is negotiating the actual purchase agreement, whether it's a asset purchase agreement or a stock purchase agreement. This typically happens along with the due diligence phase because the due diligence phase is so long that the negotiation is really happening in tandem. You probably aren't drafting the actual agreement, but you might have a chance to review it or look at certain components of it or even negotiate certain areas of it. The purchase agreement is the heart of the deal. It contains the purchase price and how that purchase price is paid, like an earnout or through stock. It contains representations and warranties about the condition of the business. It contains covenants, which are promises of what will or won't happen post-closing. It also contains indemnifications in case something goes wrong after closing. And finally, it's going to have conditions to close. What has to happen before the close will happen. Negotiating these types of agreements is really an art. You have to protect your client while not being so aggressive that you kill the deal. You're literally trading provisions, saying, I'll give you this if you give me that. And you have to do all of this while the investment bankers and accountants are breathing down your neck. Okay, phase number 5 is closing. If everything goes well and the parties are moving forward, then you're gonna get to the 5th stage, which is closing. And you're gonna need to have the finance secured, and if there's regulatory approvals, have those in place. And if there's no material adverse changes to the company being bought, then closing should move forward. Now, closing is when the money and ownership actually changes hands. It's really a flurry of wire transfers and signed documents, with everyone hoping that nothing goes wrong at the last second. Now, sometimes closings still happen in person, but a lot of times they're just on Zoom and everyone is just sitting watching and signing in their own office or conference room. There's also probably a dozen lawyers and bankers on standby in case any issue comes up. Once the final wire transfer goes through, then there's champagne and handshakes and lots of sleep for some really tired lawyers. Now, the final phase is the post-closing phase. Now, phase 6 is the final phase, the post-closing phase. Now, this is one that gets delayed a lot or it can even be forgotten, but it always exists whether it occurred or not. There could be integration issues with combining the two companies. There could be earning disputes if any part of the payout was contingent on future events happening. There could be indemnification claims if the seller misrepresented something. There's also employee transitions and retention bonuses. If you're in-house, you're going to be handling a lot of these things, whether it's the employee things or just integrating the two companies. There's going to be a lot of back and forth and a lot of operating as two companies until that integration happens. In-house, you could be dealing with the post-closing phase for years, depending on how fast your business moves at it. So what is going to be your role in an M&A deal as the attorney? Well, it's different depending on the level that you're at. If you're a junior associate, you're going to be reviewing a lot of documents, just a lot of documents. You're also going to be comparing contract provisions and flagging issues for senior attorneys to review. You might also be drafting disclosure schedules, and you'll be on a lot of calls where you won't speak at all, but you'll be taking a lot of notes. And let's be real, this is where you will learn a lot, a ton. Pay attention, don't sleep through this. You will learn a lot. Now, if you're a mid-level associate, you'll probably be managing parts of the due diligence process and helping the younger associates really learn. You may get to draft sections of the purchase agreement, and you may even get to negotiate some provisions with opposing counsel. You're also going to be focused on managing the junior associates and making sure work gets done. You may even get to interface with the client more and explain some things in plain English to them. Now, if you're senior counsel or in-house counsel, you're going to be driving the strategy of the deal. You probably will negotiate major deal points. If you're in-house, you're going to manage outside counsel. And if you're at a firm, you're going to manage client expectations. You get to make the judgment calls about what are real issues and what aren't. And you get to explain those to the business people. You also help to keep the deal on track and prevent it from falling apart. But here's the real truth. No matter what level you're at, your job is to spot risks, communicate them clearly, and help your client make informed decisions. You're not there to be a deal breaker, you're there to be a problem solver. So what makes M&A hard and what makes it so valuable to learn? Well, it's hard because the hours are brutal, the deals move fast, and they don't wait for anyone. The stakes are high, and there's millions and billions of dollars on the line. You also coordinate with a million people, from bankers to accountants to other lawyers. There's business people involved as well, and there's a lot of pressure to get it right, because if you miss something, it will blow up post-close. But there's a lot of reasons why it's worth learning. The skills in an M&A deal are transferable. They will serve you in almost any area of law that you go into. It's also intellectually interesting. You're not just reviewing documents in a vacuum, you're actually seeing what businesses are really doing, what their strategy is, and how you're making this come together. And this experience also opens doors. It makes you really marketable. In-house legal departments want people with deal experience. Law firms also value it. So even if you don't want to do it forever, it's definitely a good thing to have on your resume. You also learn to work under pressure, because this is the pressure tank. This is where it all happens. If you can manage stress, prioritize, and perform well under tight deadlines, then you've shown your worth. It's a skill that will serve you your entire career. And my favorite is that when the deal closes and you see the press release go out and you know you were part of it, there's no better feeling in the world. Like, hey, I was part of that. I knew about all of this and I was working on this before anyone else knew about it. It feels like you were in the inner secret. It's an awesome feeling. So that's it for M&A today. I would love to keep sharing all of my knowledge and tips with you. If you think you are ready for some one-on-one coaching, go ahead and schedule a discovery call with me. The link is in the QR code or the pinned comment and description below. Let's chat about your career, what goals you have, and how we can get you towards them. Bye for now, hackers.